Thank you, my Lord. My Lord, we had adjourned at the request of the Crown and the Defense that we go back and rule some authorities that will support our case. And I will first of all start by saying, my Lord, it is clear, manifestly clear, that as far as the conduct of trial under the Criminal Procedure and Evidence Act, the principle as to what should be followed is silent, and I must admit. However, my Lord, when you cross over to the authorities relating to the same subject in South Africa, let me start by quoting the learned writer, if I'm correct to call him, P.J. Swigert, in his book of second edition, it is titled Principles of Evidence, second edition. At page 347, where he deals specifically with the procedural matters pertaining to cross-examination. At page 347, this is what it was quoted. In criminal cases, it is customary to allow the accused to cross-examine in order that they are listed in their charge sheet. That is point number one. Secondly, it says, defense witnesses called by one accused may be cross-examined by the co-accused person before, this is very important, before the prosecutor can cross-examine. And then they quote a case, my Lord, a case of Rex versus Heaven. And I have some copies of the case. With your permission, may I approach the citation? The citation, my Lord, it's R versus Herwold and others. Herwold. R versus Herwold and others. Herholdt and others. 1956, volume 3, essay. Page 313. 313. Page 313, yes. Yes, with your permission, my Lord, I approach the judge's clerk to provide the copies. In that case, my Lord, as was quoted by Sweden, Becca J had this to say. The issue in that case, my Lord, was that defense during the course of criminal trial, after the accused number 3 had given evidence in chief, the question arose, that was the issue, whether counsel for the Crown or counsel for the other accused should start the cross-examination. That was the issue that has to be determined in that case. And this is what Becca J had to say. I have, during the lunch hour adjournment, taken the liberty of discussing the practice or custom with my learned brothers. And as far as I could make out, there is no hard and fast rule. The usual way is for the defense to complete the cross-examination, and thereafter, the Crown to cross reason to depart from that usual custom. And in 1974, the same principle, my Lord, was adopted in the case of S versus Lysias and another. S versus Lysias. Lysias is L-E-S-I-A-S and another. Where Hoxter J, in that case as well, adopted the same principle And in approval, sorry, citation, sorry. 1974, Volume 1, South African Law Report. And I also have the copies.
Page.
It's page 59. No, from the report should be 135 to 136. May I approach the judges like to hand over the printed copies for your easy perusal? Yes, and therefore we submit, my Lord, that on the basis of what has been presented before you, on the basis of the Swikat, the write-up Swikat, and on the basis of 2 cases presented, we submit that the last bite of cross-examination should be done by the prosecution. That's what it is.
My Lord, I am looking at the very case which my learned friend ended with, the Lysias case. My complication with the Lysias case is because it introduces an element where the court makes a remark. I just want to come to the relevant section quickly so that I may actually read that part. I think it will be on the very first page. It is at page 135. And the last part, I beg your pardon, my Lord, it is moving. Yes, my Lord. It appears on page 35 towards the end, immediately above page 136. I can count but the third paragraph, and it is written as follows: quote, it is standard practice in criminal courts that each co-accused first cross-examines the accused or his witness in numerical order, and that the state only cross-examines after this. Then see Rex versus Herhot and others, 1956. In the present case, however, accused number 1 was cross-examined by the prosecutor immediately after he had concluded his evidence in chief. The same applies to accused number 2. Moreover, at no stage did the trial court give either co-accused the opportunity of examining or cross-examining the other co-accused. End of quote. The my reading of this section leaves a proposition that the co-accused may examine his co-accused. Similarly, he may cross-examine his co-accused. Now, my lord, I want to move further and cite a more earlier case. The full citation of the case, it is beg your pardon, my lord. S versus Msimango. Msimango is spelled M-S-I-M-A-N-G-O. It is S versus Msimango and another. The full citation is 2009, all South Africa law reports, page 529, and then it has GSJ in bracket. And another alternating citation is 2010, volume 1, SACR, page 544, GSJ in bracket. My lord, the following is stated at paragraph 4 of the case, and I wish to quote it. Quote, it is so that both at common law and statutory law, an accused person has the right to cross-examine any witness called by the prosecution or any other co-accused who testifies. Section 166, subsection 1 of the Criminal Procedure Act 51 of 1977 provides, quote, an accused may cross-examine any witness called on behalf of the prosecution at criminal proceedings, and any co-accused who testifies at criminal proceedings, or any witness called on behalf of such co-accused at criminal proceedings. And the prosecutor may cross-examine any witness, including an accused, called on behalf of the defense at any criminal proceedings. And a witness called at such proceedings on behalf of the prosecution may be re-examined by the prosecutor on any matter raised during cross-examination of that witness. And a witness called on behalf of the defense at such proceedings may likewise be re-examined by the accused. End of quote. Then it continues. In addition to section 35, subsection 3, Roman figure I, or in fact the paragraph I of the Constitution of the Republic of South Africa, I will skip the citation of the Constitution. It provides that an accused person has the right to adduce and challenge evidence. A careful reading of section 166, subsection 1 of the Criminal Procedure Act invests reciprocal rights in both the accused and the prosecution to cross-examine opposing witnesses and to re-examine their own witnesses. Similarly, the right to cross-examine a co-accused or witness called on behalf of such co-accused is also extended to both an accused and the prosecution. End of quote. Now, my lord, I have a slight difficulty in this regard, which I see as a matter of practicality, which of course by both the defense and the crowd do not actually answer that question specifically. And this is the question. I stand up and then say, this witness in particular was testifying more on mutiny, and I have nothing to say. I sit. The crowd then, because they have the ambit within which they can cross-examine this witness and others. They now come and ask this witness, and they will be entitled to do so. Are you one of the witnesses that, per our case, you were not allowed to go to the police station? Well, the witness will answer whichever way he will answer. Ultimately, during that exchange, something that tends to affect the interest of accused number 9 crop up. If at all the position is, at that stage, I will not have a say. I'm comfortable that I will come and deal with it as and when accused number 9 comes in to testify, because I would not have refused my right to cross-examine. But as at this stage, nothing that requires accused number 9 to say anything would not have arisen. Otherwise, my lord, this is as far as I can conclude. Thank you, Lord.
But I'm going to be short. And I'm going to refer your lordship section 171 of the Criminal Procedure and Evidence Act before I refer you to that judgment that I raised. And I may say at this stage, my lord, given the constraints of time, I was not able to bring the judgment, but if necessary, I can bring it and bring it tomorrow on. Because even during lunchtime, where my offices are, because of traffic, time is always of essence. Now, section 171 of the CP&E reads as follows. And why I read it, my lord, I'm going to say the approach that your lordship adopted earlier on. Certainly, I've been advised that is on the day I delayed to arrive in court. It's proper and acceptable. And this is how it reads. Subject to subsection 2, every person charged with an offense is entitled to make his defense at his trial and to have the witnesses examined as the first one, or cross-examined by his counsel or other legal representative. So I submit, my lord, that the provisions of this section are broad enough to accommodate the approach that the court adopted. Your lordship, when my learned friend, Advocate Mulati, said, well, the court can make, in other words, the court can change rulings. I said the court, not Mr. Mulati, can adjust its interlocutory rulings. I refer your lordship to the case of S versus Tai. Tai is T-A-I-T-A-I. And in citation is 2023 in square brackets ZAEMHC 16. It was decided on 29 March 2023. The citation again is 2023 ZAEMHC 16, decided on 29 March 2023. I specifically refer your lordship to paragraph 75. And I may say in 1 second, the learned judge was dealing with a situation of whether or not he could reconsider his rulings on confession and pointing out. And he held that, and I want to quote him. He says, after all, rulings on confessions, pointing out, and admissions are generally interim in nature, and the court is entitled to revisit them. The court is at large to consider the confession in light of what the accused chooses to say in his defense when he testifies. The court may very well conclude that on his reading of the document, it does appear that the accused admitted to having committed any offense, or he did not admit to all elements of the offense. The point that and there are certain paragraphs where it deals with and makes the statement that rulings in relation to procedural matters, such as the one that is faced by the court is entitled at any stage to revisit them. This includes things such as admissibility of evidence or otherwise, such as confessions or pointing out. And I do not need to belabor the point. I thank you, my lord.
No response, my lord. I'm comfortable.
Oh, the last one before I forget, it's not a submission, my lord. My learned friend referred you to the book by Principles of Evidence Speaking. Certainly, he uses an older edition. In the fourth edition, it should appear on page 399, almost identical except a few adjustments on that page. In other words, the fourth edition it's of 2021. So it will appear on page 399. I'm not sure. The last time I used our main library, I cannot remember whether they had the latest edition or not, but I'll make a copy. The authors is PJ, and then I spell the surname. It's SCHWIKKARD. And others. There's quite a number of authors, and in the academic world, it's not people remember how we do it. It's ETL, et al. Yes, and so that will be page 399, paragraph 18.7 on that page. If you count below paragraph 18.7, that is the second paragraph. And His Lordship will see it's customary. Even the case they've quoted, the judge just made, the learned judge just made a ruling in half a sentence to show that's just a custom. And a judge can, because it's a question of procedure, the judge can make it valid. Thank you.
From the argument presented, it appears that the authorities suggest the procedure that I advocated yesterday, so we stick to that.
As the court pleases. Thank you, my lord. If His Lordship could bear with me. Now, Corporal, let's confirm this fact. You remember if a court martial was established, or let's start from here. I withdraw that. Are you aware that in May 2015, several soldiers, juniors, officers, senior officers were arrested on allegations or suspicion of mutiny?
Now, that you click for my hold that's what I think when I leave the sort of thing and little you look certain and how about the product of a young meeting? Yeah, but it's on a lot.
you are aware that General Letwela, the current commander, was the president of the court martial, which was intended to try them.
Na kumenya hore general to yesin game la bien ati ni na mashaliu yakana ko mashaliu
Uzalu mzumbi.
yes my lord that is so
And you surely are aware that there were various teams. I know you said you were not a member of any of those teams. There were various teams which were intended by the command of the armed forces to investigate the meeting. Are you aware of that?
now let kumenya hore tena ile abula wana nstola chini to kuna chini zile siku hore the battle ya meeting chini zile chuke tumula paso vamos stalla autona ndio
Uzalu mzumbi.
yes my lord that is so
In these proceedings, the court was told that one of the teams was called the interviewing team. You understand?
nyanya the kota se buleze kwa kiboso kwa game wa team ni ndio interviewing team ulipata wewe
Kiauka mzumbi.
yes my lord can you get that as you tell me
Were you ever called to appear before this interviewing team
na bila ka vitu wa holo taka
at any time in 2015?
kas ini kan kas masatu ni team
Hakisuka kibitwa face ngapa mzumbi.
no my lord I've never been called to appear before any team
Before the court martial, were you ever called by those who were responsible to prosecute the arrested soldiers to go and give evidence before the court martial?
na kabla kwa marshal ding la bitu yo ne ba sidle ko basha lo ba ko to na upa na ka ba mu bila ka
Hakisuka kibitwa mzumbi.
no my lord I was never called
As a soldier, are you aware that mutiny is a serious offense in the armed forces?
Very sorry. Na whatever couple million hori and meeting couple terats laudo solema I get the serious your offense is serious couple bit la mala is serious
Uzalu mzumbi.
yes my lord that is so
And it carries very serious consequences, isn't it?
me in a little cote
Uzalu mzumbi.
yes my lord that is so
And I guess this is why when you received the information from the source that you asked that their names should not be bestowed,
me
you reported.
me kwa melori la ko kwa ni kwa tuna ku social kwa ika ina mo google la ko ni bitu la nas kila la twa la what ko da we
To your superiors
ba
completely.
ba e ku sikila how
Uzalu mzumbi.
yes my lord that is so
My Lord, that is as far as I'll go with the witness.
Thank you, my lord. Corporal, tell me, have you ever been interviewed by the police in relation to this matter?
That now since I got one from the south, so is an interview that I was analytic, so
Ha ho jwalo mohlompheng ha ke so ke itse.
now my lot, I've never been called by the police for an interview.
Earlier in these proceedings, when the Crown was leading its evidence, there was evidence that there was an inquiry held in the Lesotho Defence Force, and the main issue to be determined by that inquiry was whether there was meeting or a suspicion of meeting in May, June 2015. Have you ever been called before that body and asked to give your side of the story?
I mean, when I told her, Ula, but in the Lavali and Querc of Patricia, you are what is the Lavali, not Lavali meeting as in 2015. Now, when I'm what it is was to carry you for total formal.
Ha ke so ka ke bitsa mohlompheng.
Now, my lot have never been called.
And you have always been available to the command of the Lesotho Defence Force from May 2015 until now as we speak. You've always been available to be accessed by them whenever they need you. Have you ever discussed, well, before you took the stand, or have you ever had any occasion to discuss with him the evidence that you have just given? Have you ever informed him that, oh no, at some point I met an informant who tipped us off about a certain meeting he plot?
Now, now, Laga, or Napoleon, you listen at the normal Laga, so you will look at our Mamma, coming to look at our meeting. Like a wait of the lake. But I totally.
Ha ho jwalo mohlompheng.
No, my lot, it's never happened.
Well, my lord, that would conclude my questions with regard to my client accused number 8. My colleague Advocate Mafaisa had requested me to send in for him. My lord, I just require just a moment to converse with his clients just to ensure that they are happy. Thank you, my lord. I have a few questions. Corporal, I'm going to ask a few questions on behalf of accused number 5. His name is Molise, I forget the rank. Is he a person that you know?
Yes, my lord, I do.
You remember you mentioned him in your evidence.
Yes, my lord, that is so.
You also mentioned another soldier called Hala. He was PW1 in these proceedings. Forgive me, I forget his rank again.
Yes, my lord, that is so.
Now, what is his rank?
Thank you, Ekman.
Hala.
Kana kuyo renkia hai ba di posini la scopo.
My lord, at that time, if I'm not mistaken, his rank was Lance Corporal.
Now, Lance Corporal Hala, it is common cause that Lance Corporal Hala was interviewed by the police and he gave evidence as a ground witness in this matter.
He tabit walau Lance Corporal Hala mula pengal regis polisa nila panaga upay gimana pada ile ya papato in prosecution.
Ha kaba awe ga yono mfundi.
No, my lord, I was never aware of such development.
Yes, of course, I'm just telling you that, but listen to the question now.
Check.
Now, on the aspect of the evidence that you have given the court, Lance Corporal Hala, as he was then, gave evidence along the same lines that, in fact, sometime in May 2015, there was an informant who told, who informed him and others. We now know that you are one of those people who defense force at this time that you are mentioning. Do you understand?
Kesia Musoftan, a great high Ilaya, the working school, a native in a lake or about buying about good or things in the implement in when yes, my lord, that is so. I do understand.
Now, from the onset of this case, the Crown has always been maintaining that there was no plan to commit any meeting. I'm telling you that.
But how you make a see the Sally who did that about how so about it by a meeting, the being able to allow Lordma. Checking out the law. Sally is studying a house of a meeting, our meeting. That's what I hear you, my lord.
And Lance Corporal Hala did mention who he was with when this information was imparted. You understand?
Yes, no
In
problem. On all the man of we, there was not in the beach, but you would. So this, I understand, my lord.
And that is the information he gave to the police, the investigators of this case.
Kiana, getting information of telling I first police again, but now about this when you I understand, my lord.
But today now we learn that one of the very critical witnesses, you, in this, or let me put it this way, we now know that you are one of the people who came across this information of a plan to commit meeting in the Lesotho Defense Force in May 2015.
It's not as well. We have more what that came off information in the work planning a meeting so in car Google 15. That's what it's mean.
Ya sacaron contigo.
get to me, my lord.
And do you by any chance know why the Lesotho Mounted Police Service, through its investigators, never bothered to get to interview on this subject in
No.
relation to this case?
Now, that's what I'm not supposed to say. So, no, incredible. When I did it, I saw that thing. I thought it was so. Somebody put it. Yeah, that was it. Go on, go on. That's it.
I need to hang out with you.
My lord, I have probably why they haven't bothered to interview me. I mean, that's mounted police.
Now, when accused number 5 makes his argument at the end of the evidence, he is going to argue that in fact the investigations were conducted in such a manner that they were intended to suppress that there was this information that reached the high command of the army that there was a suspicion or a plan to commit mutiny by certain people. And that will answer the question why the accused persons are said to have went to Mujema to not to arrest but to kill the deceased.
I'm still listening to you, my lord.
Thank you, my lord. That concludes our question.
My lord, up to this point, the witness has not talked about the case number 9. We have no questions.
Thank you, Lord. I will conduct the further examination. Just prepare. So that my things are good. Can you remind me your names again?
Molise, Molieleng.
Could you please allow me to call you Molieleng? You accept that I should not refer to your name. You accept that?
Thank you, my lord. I do accept.
Thank you, Lord. You will agree with me now that until now, all that you informed the court pertaining to this faceless soldier is a simple hearsay. In other words, you were told by this faceless soldier.
That is the honor opinion, my lord.
You agree with me that you informed the court that you were told by your informant, whom you did not disclose the name, about the allegedly mutiny, you were told, you don't have first-hand information. Do you agree with me?
Ka mali na go utlwe taba tsena tsa meeting ka tsa tsora Solomon ka informant ena hao empa wena ha ona taba tse ka go di tseba di le tse le direct le personal information ke tse ka taba tsena tsa motho ena go tshotwa a tla se tsola ha wena ha ona taba tse first-hand tse le direct tse go tseba di ka motho but man nine for
Ke maikutlo a hao mohlomphehi.
that is your own opinion, my lord.
No, the question is not whether it's my opinion. The question is whether you agree with me that what you allegedly told the court about the mutiny, you were told by this faceless, unidentified soldier. Do you agree with me or not?
Che potso ka eso gona ke mang go check go gona na o male nna ke di taba tsa meeting wena ha o tsi le ka motho yo a ke teng a tlause ba go so tlause in this exercise that you
Utlwile ka karolo ya mutiny ono mohlomphehi.
we have to dedicate one second. Ke na go ka male nna re bene ke batla ka go ya hao one nna ya tlake ka go ke ka ba
Ke utlwile ka setho se ne le karolo ya mutiny.
I heard from a member who was part of the meeting, my lord.
Please answer my question.
What happened?
Do you agree with me or not? You heard my question. The questions are straightforward. Yes or no? That's all that it requires. Do you agree with me or not?
Go jwalo mohlomphehi.
Yes, that is so, my lord.
Thank you. And yesterday you said the commander in May 2015 was A9. Am I correct? Yesterday.
Mahao itse molao wa sesole ka tseno se botini ne le general ka mo. Mahao Sure.
Am I correct?
Nyakane
Yesterday.
ke Mahao
Am I correct?
Nyakane
Ke kopa gore ka wa ke itse kwana ne ntse ke gopola taba tse gona tse.
Please answer my question,
Ke
sir.
e lokisetsa tsenela ka e ne le general Motsho.
I'm coming to it. I'm sorry, my lord. I'm sorry, I'm not going to interrupt. Yes, you can interrupt. I'm sorry.
since I said I was going to correct that, I corrected it and said it was General Motu. I did a correction.
Sir, could you please answer my questions directly so that we move fast? My question is simple. Yesterday, you said in May 2015, the commander was A9 before this court. Yes or no?
Mahao we think molao wa sol ka 2015 ne le General Kamuti. Ke batla gore e ka potse.
Go jwalo mohlomphehi.
Yes, my lord, that is so.
And today, you corrected that to say, no, in fact, it was Nademo Sumoto.
But that's not what look is over. You must wear any that most.
Okay.
Go jwalo mohlomphehi.
Yes, that is so, my lord.
But I'm advised that this time up is already lunchtime. Can we adjourn at this stage? It's 2:15.
We are taking our lunch ready at this stage. You come get a quarter past 15. In the meantime, please discuss
Thank you, my lord.
Yeah, that's my lord. Thank you. Thank you.
For tonight,
is a leader.